In many, not all, in many sex assault cases, there's going to be physical evidence that the prosecution is going to seek to introduce against you. It's probably going to be something along the lines of not just a statement from the alleged victim, but assuming this is an adult, that alleged victim would have gone immediately to a hospital and been given a sexual assault nurse forensic examination, sometimes referred to as a SANE or a SAFE exam. That is an RN who's specially trained to document and collect evidence of a sexual assault. So they're looking for physical evidence. They're going to collect DNA. They're going to try and collect fingernail scrapings from the victim's fingernails to see if they have skin cells underneath there that can match to your DNA. They're going to comb the pubic area of the victim, looking for your evidence of your pubic hair. They're going to look for trace of semen inside the victim's vagina or the rectal area. Physical evidence. They're going to look for trauma to the vaginal area that would indicate this wasn't consensual, it was forced. A number of different things that they're going to look at. But there are some cases where there's no physical evidence of sexual assault. It's just that person's word. So how do they build the case against you? They're going to build it through circumstantial evidence and direct evidence. They're going to get the victim's statement. They're going to get, hopefully, your statement early on where you admit to conducting this. They're going to maybe seize your phone or subpoena the text messaging records from Verizon or AT&T in order to show that there was a relationship here that crossed the boundary. Maybe you sent text messages apologizing for what happened. They're going to try and get circumstantial evidence to show that you know you crossed the line from consensual to non-consensual sexual contact with this alleged victim. In the case that it involves a child, the biggest piece of evidence against you besides your own words are going to be that young girl or boy's statements that she gives at a CAC interview. That's the Child Advocacy Center. She's going to, or he is going to be questioned by a forensic examiner who's going to ask questions in a very open-ended and eventually focused format in order to help draw out information from the child about your involvement with him or her as it pertains to that sex assault. The CAC video is usually, if it's reliable, admissible against you in trial, and that's a tough one to deal with. So there's an example of where there's no physical evidence of sexual assault or molestation, but we have the child's statement brought through the CAC video process. In many, many sex assault cases, you could be convicted without physical proof, physical evidence. Just remember, physical evidence is just one form of evidence. What is that? It's DNA, it's hair follicles, it's evidence of a brutal sex assault, trauma, injury to the victim's vaginal or rectal area, bruising on the victim showing that they were restrained. This is all physical evidence in support of a sexual assault. But you can just be convicted based upon other evidence. What would that other evidence be? The victim's state of mind when she calls. How close to the alleged sexual assault was this reported? Statements that you gave. Detail that she's able to give in her statement that can then be corroborated, like where the bedroom was, what exactly you were wearing, how you coerced her or him, how you restrained them, how you assaulted them. This is all information that, while there may not be physical proof, that person's testimony could be enough to convict you, and certainly enough for this case to be prosecuted and for you to face an indictment in front of a grand jury. How do you defend yourself in a sex case where there's no physical evidence of a sexual assault? Well, first of all, you don't defend yourself. You hire someone like this legal team, me and my team, to defend you. You need the best. Second of all, we come up with a theory. Sometimes there's real motive for someone to lie or exaggerate. Here's a classic example. You meet somebody on Tinder. You had sex with them. You go back out, you have sex with them again. Everything's great. Third time, you had sex. You didn't call her back. She didn't like the way you treated her that night. Maybe you didn't kiss her goodnight. Maybe you didn't say, hey, you're the greatest ever. Maybe you just dropped her off and kind of laughed and sped away, and she feels vulnerable. She feels disrespected. She tells her friends about it, and her friends said, don't let him get away with that. He sexually assaulted you. Now, instead of just having someone who doesn't feel like they were treated just the way they wanted to be, this has now turned into a sexual assault. So how do you defend against it? Sometimes we have to look at the motives for why someone would lie, because it's not uncommon for victims to make up allegations. And how do we uncover that? Through a careful review of discovery, conducting our own discovery. Sometimes we may have a client engage with a polygraph. That is not a lie detector, by the way. And if the client can pass it, it's something we may want to present to the prosecutor, which may give them pause as to whether or not they believe this actually occurred. And then ultimately, it's through skillful cross-examination of the alleged victim that you begin to take the state's case against you apart, brick by brick, until there is no foundation left and their entire case collapses. But there's no single way to defend. It's a process. It's a complete defense that starts with getting the attorney involved immediately after these allegations have been levied against you. A common question we get by the time we go to trial in a sex offense case is, should I testify? There is no blanket size-fits-all answer here. The choice to testify is yours and yours alone. No one can force you to testify. No one can force you to bring evidence against yourself by testifying. And if you want to testify and your attorney agrees that may be your best way out of it, it might make sense in your case. But it's a very case-by-case decision. Sometimes it's about whether or not the state can meet its burden of proof, and perhaps they can't do it without your testimony. Perhaps we can do enough damage to the state's case through cross-examination of the victim and all of the witnesses for that jury to say, I'm not really feeling this. I don't think that this guy I don't think he's done it. I don't think the state can prove this case beyond a reasonable doubt. Sometimes it's a game time decision. The state has closed its evidence, they've rested, and we're not quite sure that we've gotten the ball across the goal line. We prepared you for testimony and the possibility of what it's going to look like if you testify, as well as what cross-examination is going to look like. But we're not sure we're going to do it until that moment. And then we have another discussion. And perhaps at that time, when we put on our defense, you do testify. Because in some cases, juries want to hear from clients and they want to hear someone say, I didn't do it. And they want to hear an explanation. Sometimes they're not going to get that explanation because it's not in your best interest to testify. It may be more damaging than helpful. But again, that's a case-by-case basis. If you're under investigation or you've been charged with a sex crime and you've got questions and you need answers, give us a call. We're the team. We'll put the defense together. We'll get rolling as soon as you're ready.